So now moving on to, nuts and bolts of regional centers, and that too from a standpoint of, what do regional centers actually do? And Rohit, I'm going to start with you on this one. What is it that regional centers do, and what is their relationship with the project?
Okay. So regional centers are a USCIS approved entity that is permitted to sponsor projects within a certain geography. The geography is limited in scope. There is no regional center that covers the entire country. And their sole goal is to stimulate economic impact within their approved geography. What they are also allowed, as Nima had discussed a little bit earlier, is to be able to sponsor projects so that we can count the indirect and induced jobs. So as an example, if we're building a hotel, so let's take a direct EB-5, which we talked about, as well as a regional center EB-5. In the direct EB-5 context, you're building your hotel. The investor goes in as a standalone investor under the Reform Integrity Act today. The hotel has to get built. And so once the capital goes in and gets pumped in, the developer will build everything, and then the developer will eventually operate the project. The jobs that are going to be attributable to that particular investor out of the direct EB-5 would be the full-time W-2 jobs. And so what is required in that instance is that developer operate the hotel for that 8-9 year period, as Nima had talked about. And if they successfully do that and maintain the jobs within the hotel, then the investor would be eligible to remove conditions on their green card, right? Assuming source of funds and everything else is clear. In the regional center context, same hotel program sponsored by a regional center, developer builds. But let's assume for whatever unfortunate reason, the developer is unable to operate the hotel. Half-built hotel, fully built hotel never operates. Well, jobs from that perspective, though, are created by virtue of the indirect and induced expenditures. So they spent 10 million on hard construction, 5 million on soft construction, FF&E, throw it into economic multiplier, and as long as it's under the auspices of a regional center, the investor will get the allocable jobs. Yes, their money may be stuck and they may not be able to get it, but at least they'll get the immigration benefit. So a regional center is there to sponsor the fund. They enter into an agreement with the EB-5 entity, the new commercial enterprise, as we call it. Investor Invest becomes a limited partner or an LLC member. And there is this agreement whereby the regional center will offer certain duties and obligations to the fund. They will monitor what's going on with the fund. They will keep records. They will ensure there is compliance that's ongoing. They will have annual reporting that they have to provide to the United States, to USCIS through something called the Form I-956G. They are also subject to audits and visits by Department of Homeland Security. And they just have to ensure that there are no third-party persons or brokers that are mismanaging or doing something incorrect. If you kind of look at the way the program works, USCIS has jurisdiction over regional centers, and they have jurisdiction over the underlying EB-5 petitioners. They don't technically have jurisdiction over projects. Can they, quote, bar the projects under the new EB-5 Reform Act? Yes. But can they do much more than that? Not really. But the effect of terminating a regional center or the effect of terminating an investor petition is much greater. They also have the ability to terminate the fund. And so that important relationship between the EB-5 fund and the regional center is sacrosanct. Now, what's the other element of how a regional center is affiliated? In some instances, the regional center is affiliated with the EB-5 fund. In some instances, it's completely unaffiliated. And that's something that's going to be disclosed in the offering documents, something called a PPM, the private placement memorandum that each investor will be provided, that talks about all the conflicts of interest that exist. If the regional center is affiliated with the fund, then there's obviously that relationship. There's an ability for the regional center to monitor what's going on. And there's also some cost savings. If the regional center is unaffiliated, usually the relationship is a little bit more expensive. There is a lot more, there's an arm's length third party element. So most cases, most regional centers that are in the business, they like to maintain their own regional centers. And there's a good reason to maintain your own regional center because if you rent a third party regional center, and that regional center screws up, even though you have an agreement, it could impact your fund, it could impact your investors. B, you know that you can't control what the regional center does with other projects. You only have a one-time relationship with what you have, and it's very difficult to do much more because the regional center will enter business with a lot of other groups. So they're different models. And what we've noticed over time is as developers and as funds are doing deals around the country, either A, they try to form their own regional center, or B, they end up having to rent. So it's not necessarily a bad thing to rent, it's just you go in eyes wide open. It's a heavily negotiated document. Both sides are at arm's length, the loggerheads in a sense, because they both want information, they both want to protect the integrity of their funds, and they also are worried about any imposing liability that may stem from that. So I don't know if that answers your question.
It does. Thanks, Rohit. Anu, so I think of regional centers as watchdogs on behalf of the investors. Do regional centers have a right to sue the developer if they don't perform or try to abandon the project?
So I'm going to defer to Nima and Rohit on this because I deal directly with investors. So
okay, Nima, then the question's to you. Do regional centers represent the investors? So do they have the right and ability to sue the developer in case things don't go right, or the developer tries to abandon the project?
I think a better. I mean, certainly I represent regional centers and project, but I think it's a better question from my older half. But I like talking, so I'll answer anyways. One thing to keep clear. And I'm guilty of this as well, we within the industry use regional center synonymous for a lot of different entities involved in the EB-5 process, but they are not. As Rohit said, a regional center is a USCIS licensed entity to sponsor projects. It is not the entity that you are investing in. It is the entity that brings projects to market and helps seek financing for those projects. EB-5 investors then invest in an entity altogether, and that entity either makes an equity or debt investment within the project. Along with that investment are covenants with the developers, loan agreements, maybe construction draws, an allocation of money based on development and performance from the developer. If those covenants are broken, if the loan terms are violated, if the project doesn't move forward, and then all of this is fact-based, that is what gives you grounds to move forward with a lawsuit. The United States is great. You can file a lawsuit at any time for whatever reason. I remember when I first started my career as an attorney and I got a lawsuit and I was like really scared. I think I even called my mom saying like, what is going on? And then I realized you just get sued all the time, even though you had nothing to do with anything. That's just kind of the job. So I think, investors, if something happens where they have lost the investment or the project hasn't moved forward, litigation is obviously always there on the table. But what is really important in an EB-5 project is picking your partners. Because just because a project doesn't move forward doesn't mean there was actually fraud or willful misrepresentation or failure. You could have just invested with idiots that were not capable of getting what they wanted to do off the ground. And I think if you look at the history of the EB-5, there are a lot of people that are not capable developers that jumped into this industry, spent the EB-5 money, and were not able to accomplish the ultimate goal because it is not their background. And just because someone failed doesn't give you ground for litigation. Of course, if there is fraud or misrepresentation, and we have seen that in a number of EB-5 projects as well, you definitely move forward with litigation. You try as best as you can to gather your other EB-5 investment colleagues to come together as a class and move forward with litigation. But I'll turn this over to Rohit, as that's one of his specialties these last few years.
Yeah, so I think, the direct question is, can the regional center sue for performance the developer if the developer is not doing what they're supposed to do? It really depends, right, on what the agreement stipulates. In some instances, you will see, or the investor will see, if they are working or they've invested with a particular third-party EB-5 fund that's rented a regional center, they may have as one of the documents that they need to acknowledge or execute waiver of liability against any claims against the regional center, because the regional center stipulates there, like, look, we're simply sponsoring, we have a third-party agreement with this fund, with this EB-5 entity, and we are going to do all reporting, we're going to comply with the RA, but we are not there for the day-to-day. And so if the fund screws up, you can't come after us, Mr. Jervis's investor. Separately, the regional center and the borrower or the developer, there really isn't a direct tie in most instances, right? Unless there's an affiliation upstream. And that affiliation upstream may permit the right hand and left hand, if they're affiliated, to make an argument, but only if they're party to a loan agreement or only if they're party to some other document that says that they have conformity there. So I think in a direct instance, can the regional center go out swinging and sue? Sure. As Nima said, anyone can sue. Are you likely to get it tossed out of court? Probably, because there is no nexus there. I mean, what gives you the basis? What's your standing to actually go after them? But the other element that I would be more concerned with if I were an investor is understanding who is actually watching my back, who's watching my investment. So the manager of the fund is the most critical element. That particular group, are they viable? Do they have the history? Do they have the background to actually navigate and protect my interest as an investor? Two, is there a strong loan agreement that allows them to protect my interests? And in the event the developer does something, what happens there? And then three, who is the regional center who's running, back end there to actually report to the US? If you have strong elements there, there is definitely going to be a good, recipe for success. Now, I will mention one thing that I talked about earlier, which is the concept called debarment. What was interesting about the EB-5 Reform Act is they've put in place this ability where USCIS could come in and terminate regional center, EB-5 fund, or a job creating entity, which is effectively the developer. If that happens, there's protections. Under the old EB-5 law, there really were not these protections where developer screws up and then the investors are toast. There is now new language, which obviously is still subject to a lot of guidance, a lot of policy that's forthcoming. We've not really seen how it applies. That will allow some protections for the innocent investors that are affected by something the developer did do or did not do. So I'll leave it at that because we can't really talk much about it until we get it.
Great. Thanks, Rohit.